Paano nga ba natin masasabi na ang mga magulang ay naging mabuti sa kanyang anak
Hoy, kuya! Ito
sa
pala, nakahanda
atensyong
na. Ay, dad, baon mo, ha?
binibigay nila? O hindi kaya
Anak!
sa pagtuturo ng tama at mali?
Ate, tapos na po ako. Salamat po.
Sapat na ba
Nak!
na sila ay tapat?
Sobra yung bayad mo. Ganun po ba? Thank you po.
Para patunayan lang
Dito na ako, ma.
Uy, Dad,
na sila
nakauwi ka na
Pagod
pala.
na ba?
ay karapat-dapat?
Anong ginagawa mo dyan? Kumain ka na ba? Tara, kain tayo sa loob.
Siguro nga
Uy,
masusukat
may bisita,
ang pagiging
Kaya
magulang
mas masarap kumain.
sa pag-aalaga sa kanilang
Masarap
anak.
yan.
oo naman, no?
Thanks, ma.
Pero paano kung walang anak? Natutumbasan ng kanilang pag-aaruga. Ano nangyari?
Kumusta anak namin? Kinalulungkot ko. Hindi na namin naagapan ang pagsali ng dugo. Naging matindi ang pagdurugo sa loob ng kanyang katawan. Dahilan ito ng kanyang tagli ang pagpanaw. Mrs.
Ang sigurado ko lang, bago sila maging mabuting magulang, ay naging mabuti silang tao. Na kahit gaano kahirap ang buhay, ay hindi nila kayang gumawa ng mali. Hindi nanlalamang sa kapwa at handang tumulong sa nangangailangan. Kaya naman, sigurado ako na sila ay magiging mabuting magulang sa'yo. Bunso.
Happy almost 1 year to my fellow kapandemics. 14 days to go before we celebrate the anniversary of the enhanced community quarantine. So, how are you? Have you realized that we are on the second semester of being webinar mates? But you know what? As much as we want to see each other, let us just hope that this does not turn out to be a 4-year course. But let me see first, from what city are you watching this right now? Kindly comment down below. For those who are watching via Zoom, kindly type in the chat box. All right, I can see from Cebu, Manila. So good afternoon, everyone, to our almost 300 participants here. Yeah, Bohol. Thank you for sharing your time with us. Maayong hapon sa mga Ilonggo. And maayong hapon kaninyo tanan diha sa Cebu, Dumaguete, Davao, CDO, and the rest of Mindanao and Visayas. Magandang hapon din po sa mga taga Luzon and of course, annyeonghaseyo sa mga ka-Netflix natin dyan. So are there anyone watching outside the Philippines so that we can adjust our language accordingly? All right. So anyway, welcome to our very first HR Cafe this 2021. So to officially start, it's my honor to call on our dashing and inspiring Senior Vice President for Marketing and Sales Group and Regional Operations, Mr. Norman Amora. Sir,
Hello, Ivy. Can you see me? Maayong hapon sa inyong tanan. Good afternoon to everyone. On behalf of Intellicare, we welcome all the participants. I see 294 and counting. From north, I saw somebody all the way from Baguio, all the way south. And it's heartwarming to see everyone. And despite your schedule and all, you graced us this afternoon. I hope everyone is safe and healthy. Like what Ivy was saying, it's almost a year, and sometimes we've developed new habits all of this time. Just a little bit of tidbit of HR Cafe. We started this around 3 years ago, 2018. I remember it was in a small coffee shop in Cebu City. We wanted to foster ties with our existing clients, our prospective clients, our partners, our stakeholders, and we wanted to empower them with the right tools, knowledge, and resources in the realm of holistic healthcare management. But like what Ivy is saying, this afternoon, it's a different scenario. We opted to go webinar, and we felt it is also very it's nice that we have to get to see 300 people all at the same time in this Zoom meeting. This afternoon, we opted to segue a bit from talking about healthcare, and we wanted to shift to something we feel is vital information and knowledge to all our participants: labor. Labor concerns during the pandemic. And we are fortunate this afternoon, we have our corporate legal officer, who is also the head of enterprise risk and management and compliance, Attorney Michael Balbanero. And we hope Attorney Mike will be able to enlighten you on a lighter mode to understand the local labor laws that may concern your organization. And we hope that we enjoin you to send in your feedback, your questions, your concerns, clarifications. And if we have ample time between this hour, hour and a half, we will respond to them. And if not, we will have our team answer you via your email addresses. So I guess minus the coffee, the free coffee and the merienda, sit back and relax. Thank you very much for your time. And I hope you learned something this afternoon. So back to you, Ivy. Let's start the ball rolling.
thank you, Sir Norman. Minus the free coffee, but go ahead, get your coffee. Anyway, we are just getting started. So let us ensure that we make our afternoon as relaxing and engaging as possible by actively participating. Yes, as mentioned by Sir Norman, our topic is actually very serious and all of us can relate, whether you are an employee or owner or a private citizen, because ignorance of the law excuses no one from compliance therewith. And at one point, we had questions that trudge along legalities. The topic of law is actually very wide. In fact, to be a lawyer, you have to pass one of the hardest exam where you had to take 8 subjects in 4 Sundays. But we will compress it in a little over an hour. So to manage our time, we will contain our discussion around labor concerns during a pandemic with the help of Attorney Michael Balbanero, our Senior Legal Officer from Intellicare. Attorney Mike, as we fondly call him, have over 13 years of experience from being a litigant lawyer handling cases in corporate practice, labor and land disputes, special proceedings like ejectment, child support, rep live-in, temporary restraining orders. Sounds sexy, Attorney Mike, ah. civil and criminal cases, administrative and tax cases, among others, all from his collective experience as junior associate of Algara Miranda law firm up to being a partner at Zambales Balbanero Gonzalez and Associates. He also became an in-house counsel of a group of company composed of mining, heavy equipment provider, construction, shipping, and aviation. And of course, now as the legal officer of Intellicare Group. So yes, be ready with your questions. I'll now share the screen with Attorney Michael Balbanero. Attorney Mike, you're on mute. Can you please turn off your mic?
All right, sorry for that. But anyway, thank you very much, Ma'am Ivy and Sir NPA, Sir Norman, for that tremendous and delightful introduction. And good afternoon, everyone. It's my pleasure here to discuss with you right now our topic regarding labor concerns, especially now being affected by the COVID-19 pandemic. To start off with, I would like to discuss first with you the rights of the employer, and later this will discuss the right of the employee that are now being very much get affected by this pandemic. As for the right of the employer, please, I will introduce you the management prerogative doctrine. Next slide, please. What is this management prerogative doctrine? Well, basically, it states that every employer has the inherent right to regulate according to his own discretion and judgment all aspects of employment. This includes hiring, work assignment, working methods, the time, the place, and the manner of work, work supervision, transfer of employees, lay of workers, discipline, dismissal, and recall of employees, as stated and held by the Supreme Court in Rural Bank of Katirklan versus Joe v. GR 169750, dated February 27, 2007. As we can see, very broad management right, how to handle, how to run or operate a business. What are considered this? What are the rights considered on this management prerogative? The rights are right to return of investment. Of course, you will not establish a business if you don't get your return of investment or earn a profit. Right to prescribe rules. These are the rules that the employee or even the employee themselves has to follow in order for a very efficient running of business. This includes, of course, policies, code of discipline. Of course, also includes right now the work from home arrangement or other flexible working agreement. Already been submitted to the approval of the DOLIT for the Department of Labor so that they can run the business efficiently even during the pandemic. Also, under the management prerogative, it is the right of the employer to select their employees. Not even the government can interfere or whatever terms or conditions that the employer may set up to the employees regarding their contract of employment. And of course, right to transfer or terminate employees is very, very important right now because there are a lot of employees are losing their jobs due to this pandemic. Is this right of the employer an absolute right? No. Under the law, it's not. It's subject to two limitations. What are these two limitations? First limitations, of course, is the compliance for the minimum requirement of the law, which is basically the labor code. So even if the management will try to use its prerogative to run its business, the rules and regulations that they will issue should always be conformed to the minimum standard prescribed by the labor code. Not only labor code, but also other laws which usually help or protect our employees, Like for example, anti-age discrimination law, Magna Carta rights of women, those kind of things. When an employer try to set rules, this he or she should follow this requirement of the law and should not transgress it. If he does, his management prerogative loses its power, and our government will try to penalize him. Another limitation subject to the management that will limit the management prerogative is the principle of equity and substantial justice. So what is this principle? That every rules and regulations or policy issued by the employer that will help, that will oblige the employee to follow the business, it should be always be fair and reasonable. So even if, let's say, he the policy of the policy of the employer is within the minimum standard of the law, but if he enforce it not in a reasonable or fair way, that can also be considered in violation of the rights of the employee. He cannot use management prerogative. In short, he cannot use management prerogative in running a business to circumvent these rights of the employees. Next slide, please. As we already mentioned, the rights of the employer is very broad. Now we go to the rights of the employees, which are basically now get very much affected by the COVID-19, which these are, we have to, I enumerated into four, and these are security of tenure, work days, work hours, wage and wage-related benefit, and safe working conditions. Basically, all of this, these four enumerated rights is actually being used or existing way before the pandemic. However, because of this, right now, because of the circumstances we are facing and due to national health emergency, these rights of the employees are now being affected very, very, very much. Next slide, please. What is security of tenure? Where basically you cannot remove an employee. He is protected if he's a regular employee already, even probational employee. He is protected of his tenure of his job. He can only be removed only for just cause or authorized causes and after observing the due process. Okay. Next slide, please. So what are these just causes that the labor law wants to say? So basically there are five just causes that our law state. No, we will discuss it one by one, and these are of course serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection of his work. Serious misconduct refers to improper behavior or derelictions of duty which is willful in character and implies wrongful intent. Please take note of the word wrongful intent and willful in character. The conduct must be with the wrongful intent of the employee, and it is willful. It should not be merely an error in judgment. Moreover, the act itself must relate, of course, to the performance of the employee's duty and must show that the employee has become unfit to continue working for the employer. What is a good example of this serious misconduct? If you remember one time during a Zoom meeting of this local government officer who were caught during the Zoom meeting doing some inappropriate act with the secretary. And most of the board members saw what really transpired there, where that is considered a serious misconduct. So if you guys are in a Zoom meeting with during the company hours or work hours. Be careful of your actions. And if there is already, if you see it doing some inappropriate act or immoral act or even obscene gesture, it is be considered a ground for termination of your employment. Mm. And next will be the willful disobedience. What is the willful disobedience? Intentionally not following a reasonable and lawful orders made by the supervisor in connection to the employer's duty. Again, I will emphasize the word intentional, and that the lawful orders must and the orders of the employer must be reasonable and lawful in order for this ground for the employee to be terminated or at least be suspended or penalized under the law. What constitutes reasonableness? Well, it all depends on case by case basis. There is no hard fast rule regarding reasonableness. In some other cases decided by the Supreme Court, reasonableness can be determined on the circumstances of the case. What we going to see, of course, lawfulness is very, very basic. It should not be transgressed any lawful norms or whatever lawful compliances that we need to follow. So, if again, what are the good example for willful disobedience in case of, especially during the pandemic, like violating company policy? There are right now, of course, there are a lot of company right now doing work from home arrangement or flexible working hours, flexible working arrangement. And if there are policies issued in order how to do your job during this arrangement that you have with the employer, if you willfully, I said again, willfully intentionally disobey or violate this policy, uh, this willful disobedience ground for cause of for just cause for termination can be used against you. Okay. Another just cause that that the law provides for termination is, of course, is the gross and habitual neglect of duties. What are these? The neglect must be gross. Again, we have to emphasize the word gross. It's not merely trivial. Mere errors in judgment is not enough for you to be terminated of your employment. It should be something that actually transgress public morality and decency, or even it will only create an environment in the workplace, a very not nice working environment, and that the action also must be habitual, repeated performance. One single isolation act cannot be considered a ground already for termination. It should be habitually done. So what are these kind of habitual? Of course, tardiness and absenteeism. Those are kinds of gross and habitual transgression that the employee may commit during this trying times. Even if there is a work from home arrangement, agreement, or flexible working hours, of course, there is a policy. Of course, you have to report regularly to your supervisor, and failure to do so, willfully, intently, repeatedly done, can be used it against that such employee for termination of his employment. Okay. How about abandonment of work? There are a lot of right now who during the work from home who does not regularly report to work. Is that considered gross and habitual? Well, it all depends. If abandonment, to be considered abandonment, there must be an intention of the employee to totally discontinue his employment already without intention of returning back. So if there is an inclination on his part na he will return, it cannot be considered a total abandonment, and it cannot be used as well. It depends on the case. It depends on the case of the the circumstances. But basically, the basic premise is it should be totally abandonment without any intention to return back to work. Okay, and then we go to another just cause is fraud or willful breach of employment. This refers to dishonesty or loss of confidence. The disposition of the employee to cheat, to lie, deceive, defraud, and become untrustworthiness or lack of integrity, lack of honesty, or even a disposition to defraud the employer. This is also a very, very good ground for termination of employment. Um, Example, let's say issuing a falsified medical certificate. He doesn't want to go to work because for some reason, let's say there is a return to work order made by the company to return back to the work site, but he doesn't want to go to work for some reason that he only knows, and he submitted a falsified certificate, medical certificate. Again, that is a ground for termination of employment. What is we considered loss of confidence? Loss of confidence for you to be justly terminated in your employment. It literally or should be applied to two kinds of employees. First is such employee involves or occupying a position of trust and confidence. These are, for example, mga managers or supervisors. You hired them, they have a high position because you have a very, very good confidence on their ability to run your business. So if this loss of confidence happened because of such act, it can be a ground for his or her termination. Or it also apply to any employee who routinely charged with care of the company's property or money. Regardless his position, if his duty to guard or it is in his care, this company property or funds or misappropriated such funds or money, that can be considered, of course, as loss of confidence on his part and can be terminated. One good question there is if such employee misappropriated the funds under his custody, but eventually he tried to return it, will that exonerate him for violation of his contract of employment? Well, the Supreme Court said no. Once you have already transgressed, even if you return the money, or even if you didn't get any pecuniary gain from such loss of the funds, you can be validly terminated on loss of confidence. For the commission of a crime of offense, please take note that the commission should be against the person of his employer or immediate members of his family. It doesn't say commission of a crime against co-employees, but against the person of his employer or immediate member of his family. This includes, of course, spouse, ascendants, descendants, legitimate, natural, adopted brothers, sisters, employer, or sisters of the employer, or his relative by affinity in the fourth civil degree, or those affiliated by consanguinity within the fourth civil degree. So if the crime was committed not against those mentioned people, this ground will not apply for just cause termination. And finally, another ground is other similar causes. This clause, this provision is a catch-all provision. If the action of the employee is not found particularly in the already discussed causes, the employer can use this clause, other similar causes, for a proper termination of the employer. So it can be used in any circumstances, provided, of course, no, it should be always be used in good faith by the employer in justifying the termination or penalizing the employer. Okay, next slide, please. The just cause, let me emphasize first, the just cause is the action of the employee for him to be terminated. Now, we go for the authorized causes. This authorized causes is now the act is now on the employer in how he can terminate employment, especially right now. This is prevalent right now. There are a lot of closing. There are a lot of businesses are closing due to loss of business or operation because of the pandemic. No, and these authorized causes now are very used most of the employer. What are these? No? Let's discuss it one by one. The installations of labor-saving devices. What are these installation of labor-saving devices? Again, the law provides, the law gives the management its prerogative how to run its business. If he thinks, let's say in a manufacturing company, he thinks that because of it's so hard for now for employees to go to work on the work site, and he will introduce a new machineries so that his operations will still continue despite lack of employees going to work. This is a well valid ground for him. It's a prerogative for him to do so, and he can use these grounds to terminate those employees affected by the imposition of these new machineries. Or even in BPOs, I heard one lawyer friend of mine who works in the BPOs. There are now already employee using some new computer software programs that will try to at least reduce the BPO agents. And under the law, this is a very, very valid management prerogative to do so. And using such, the employer can terminate employees for that. And of course, redundancy usually happens when there is overhiring of employees, especially before the pandemic. If the business is booming, especially as what happened during the airline industry, there are a lot of troubles. They're hiring a lot of employees, flight attendants, pilots, so that they can run the business and the operations efficiently and getting maximized profit from it. However, after the pandemic, it happens na there is a decrease in the travel, and those overhired employees can be terminated due to redundancy. Or even, let's say, right now, if some operations will be transferred to another site because in one location there is a very strict quarantine procedure. It is under strict quarantine, community quarantine, and the other part of the business is under the GCQ, and he will try to transfer the employees to the other part which are not very strictly enforced yung quarantine, no? And those affected can be considered redundant imposition. So it's a very, very valid use of management prerogative on the part of the employer to terminate. Okay. Another one is retrenchment. This is if retrenchment is always used by the employer in reductions of cost and to prevent losses. This is now, as we have seen with the Philippine Airlines, they use this retrenchment already. A lot of employees has lost their job. In order to prevent further losses due to decrease in travel, the the management of the Philippine Airlines or even Air Asia, I heard. They already retrenched a lot of people. And of course, closing or cessation of operation. If already there is already, you cannot already operate the business for profit and is already in the brink of bankruptcy. That of course the law gives the employer to close his business already. Even if, and I also like to say that even if there is no business losses, if the employer decide he doesn't want to continue anymore his business, even if it's gaining profit, he is allowed to do so, provided of course he has to follow the requirements of the law. What are the requirements of the law for these authorized causes? First, the employer must submit notice to the workers affected by these authorized causes at least a month before the period of their termination. And such notice should also be given to the Department of Labor for notices. Okay, and that notice should be accompanied by separation pay. All those affected employee who will be terminated due to these authorized causes used by the management must receive separation pay. Separation pay is usually equivalent to 1 month pay for every 1 year of service. Okay. However, if the closing is due to, if the closing or cease of operation is because of bankruptcy, there is no separation pay. The law allows that. Of course, it's very logical. Wala nang pambayad eh. Paano sarado kumpanya? Okay. So we have to follow that two notice rule. That notice required by the company for a valid use of authorized causes for terminations of employees. Okay, next slide, please. Next slide. Yes. Before I forgot, in the just cause, no, I failed to mention, no, what is the due process needed for the just cause. There is a requirement of two notice rule. First notice, if the employee committed some transgression, that he should be penalized either to be suspended or terminated from his job. The employer must give him first a notice to explain for him to defend himself regarding the transgressions that he made. And the next notice will be the notice or the explanation of the employer on the findings of the documents and all the evidences that he truly did, the employee really transgress or breach his contract of employment and deserve to be terminated. Okay, if we don't follow that two notice rule in the just cause for termination, the employer will be subject to penalty by the Department of Labor. Right now, the penalty for not observing due process, I think right now is the amount is 50,000. I'm not sure if it's higher now, but it's 50,000. Even if the grounds for termination is valid, you will be penalized because of not observing the due process. Okay. Before the issuance of that guidelines, before mas bigger ang penalty binibigay sa employer for not following the two notice rule. Ang nagiging penalty before, nung wala pang limitations yung amount for violation of due process, is the amount that the employee terminated should get at the time of his dismissal up to the time of the resolution. So parang malaking back pay ang bibigay mo sa kanya. However, it was corrected already by our congressmen who create or do laws, and now is already the amount is 50,000 pesos. Okay, so I hope that is clear. So what's another right of the employees now greatly affected by this pandemic, the work days and the work hours. What is this work day? Work day refers to the day during which an employee is regularly required to work. Hours of work refers to all the time an employee renders actual work or is required to be on duty or to be prescribed workplace. The normal hours of work in a day is 8 hours. This includes break or rest period less than 1 hour, but exclude meals period which shall not be less than 1 hour. Okay, so that is the basic rights of the employee regarding work days and work hours. However, of course, pumasok na po si pandemic, no? Next slide please. Now there are a lot of issuance under the issue by the Department of Labor and the DTI under the power of the President, as covered by the Bayanihan Act, giving him more power to mitigate this national emergency right now. So even created the AITF, the main task force in handling this COVID emergency. And because of this, they have the power to create or issue guidelines now to mitigate business losses and balancing the right of the employees regarding this right now, like work hours or work hours or work day. So one of these guidelines is Labor Advisory number 9, series of 2020. What is this now? This is the guided implementation of flexible work arrangement as a remedial measure due to the ongoing outbreak of coronavirus disease of 2019. It refers to the alternative arrangement or schedules other than the traditional standard work hours, work days, or work weeks. The effectivity of the implementation, of course, there's a requirements by the law that if you're going to try to use this flexible alternative arrangement, you have to submit such arrangement to the Department of Labor. So what are these schemes na as suggested? I said suggested, no? Kasi there are other schemes that the employer can use as his prerogative. What are these suggestions by the Department of Labor for flexible work arrangement? Reductions of work hours and work days, rotations of workers, even forced leave. Now they are allowed to do so just in order to mitigate and prevent further losses of business. Next slide, please. Next slide. Yeah. So reductions of work days of work hours. What is the other one? What is this reductions of work days and work hours? Can you this is reductions of work days and work hours. This is a shortened plan for working hours, work days. Workers may continue to earn their wages, but they will be reduced. Their pay will be reduced due to the decrease in working hours of work days. If in a normal times, reducing payment of work can be considered diminution of benefits. But because of trying times right now, our government, our law now allows for the decrease of working hours and work days without affecting diminution of benefits of the rights of the employee. The decrease in time of job or work day shall not be paid in compliance with the concept of no job, no salary, no job, no salary, no work, no pay. Still, this doctrine, this principle still applies until now. If you don't work, you don't get paid. An immediate decrease of compensation resulting from reduction of work does not break the law, even the non-reductions of benefits. No? Again, because of the trying times right now. So before the pandemic, it is a transgression on the rights of the employee. But right now, because of the pandemic, our government and our law now allows for the reduction and will not in any way affect the benefits, the usual benefits of the employee that they get during normal times. Next slide, please. Okay, in connection with the Department Labor Advisory Number 9, again, the Department of Labor issued Labor Advisory Number 17 series of 2020. What is this? This is the issuance of the Department of Labor, highly encouraging. Again, I try to use the word highly encouraged. It's not mandatory. Highly encouraged to use work from home telecommuting for employees in business industry, which is already allowed to resume operation under the modified enhanced community quarantine or general quarantine. This labor advice spells out the alternative work arrangement besides the one issued already under the Labor Advisory Number 9. Parang pinalawak lang niya yung Labor Advisory Number 9. And here, he tried to give more schemes, more options for the employer, how to use this alternative work arrangement. This is, of course, with the purpose of protecting the job, preventing closures and terminations of workers. So, ang magiging the most basic for this, of course, is that due to national emergency, this very measures allowed by the government is in consonant to protect the jobs and prevent closures. That will help, of course, balancing act again the economy of our economy affected because of the pandemic, and of course, balancing also the workers' right for security of tenure, loss of benefits and wages. Next slide, please. Well, so under the Labor Advisory Number 17, what are suggested alternate work scheme, work from home arrangement, as already mentioned, transfer of employee to another branch, if applicable, assignment of employee to another function or position in the same or another branch or outlet, as already discussed, the reduction of normal work days or work hours, job rotations, partial closure of establishment while some department or unit still continue, and other schemes if the employer thinks there are other schemes, how to create alternative work schemes, he may do so, provided again it should be used in good faith and not to circumvent the right of the employees. Okay, next slide, please. We actually don't have a very clear rules being provided under the work from home arrangement. The most nearest equivalent here under the legislation is the Telecommuting Act of Republic Act 11165. This is so if you are under work from home arrangement, the employer should follow the minimum requirement of this Telecommuting Act, Republic Act 11165. This is in light of the alternative arrangement enabled by the latest communication technology that allows employees to perform their work from home. Next slide, please. What are the basic rights under Republic Act 11165, which should be complied, which the employer should comply while his or her employees are under work from home arrangement? Of course, the employee should always still have to receive the same rate as if they are working under the normal workplace. This will also include, of course, the payment of overtime, night shift differentials, and other similar benefits. We also have the rights to the rest period, regular holidays, special non-working holidays. Of course, the workload should also be the same. Unless, of course, if he's using other schemes, reductions of work hours, it should be used also. You should also have to consider that. Of course, it doesn't remove the right of the employee to have same access to training, career development opportunities, and or receive appropriate training regarding technical equipment at the disposal and characteristics and conditions of telecommuting. And of course, it's a basic rule, basic right of the employer that his collective rights uh, shall not be barred from communicating with workers' representative. This is regarding if there is an existing union collective bargaining agreement, working from home should not in any way remove that right for him to join any association if there is, if applicable. Okay, next slide. Next slide. So again, we go back to no work, no pay doctrine because again, because of this work from home arrangement or other schemes, there is, as I mentioned before, it is still a principle of law that if you don't work, you don't get paid. So until now, this still applies even during the COVID time. If you don't work, if there is suspensions of operation due to loss of business, if or try to suspend the operations because of the pandemic, if you don't work, you don't get paid. That's the basic principle. No work, no pay principle contemplates a no work situation where the employee voluntarily absent themselves. So that's it. So that is the no work, no pay doctrine. It will apply later, especially during the safe working conditions that allowed by law. If you can refuse to work on site, what are the remedies of the employer for that? So next slide, please. As I mentioned before, is reductions of work days considered diminution of benefits? Well, no. In one case decided by the Supreme Court in Coca-Cola Bottlers Philippines versus Iloilo Coca-Cola plant employees. No, it says that no diminutions refers to reducing benefits that are discretionary given to employees, which cannot be withdrawn as they are given based on contract or practice that ripen over time into policy. Giving that decisions by the Supreme Court and now applying it to now, reductions of work due to legitimate business reason. Management reduces work by rotation, 4 or 3 days work week, or shortened work hours. Such is a valid diminution. The rule of no work, no pay or fair days labor is that fair days wage is not violated. To pay employees without leave credits, even if they are not working, is not a legal obligation even prior to the COVID-19 situation. So I have to take that in consideration for those people, for those employers who are now contemplating of filing a complaint with the Department of Labor because of what they were before the COVID, they were earning this their salaries this much, but now because of the reduced work or other alternative schemes, no, if they want to file a case, I think they should better not do so because right now the law allows the employer to have that kind of alternative use to mitigate further losses. Okay, next slide, please. How about temporary layoff or forced leave? Again, as already mentioned, the Department of Labor have issued guidelines for this. They said, yes, it's a prerogative of the management to make a temporary layoff or forced leave. Under this, if you are under temporary layoff or forced leave, you are not paid. Again, using the no work, no pay principle. Arrangement must therefore, provided that the requirements of the law should be followed, that the arrangement therefore must be valid and in justifiable grounds. So what are these? No? Of course, to prevent further losses, to protect employees from further infections from the COVID-19. If the temporary layoff is used to circumvent paying the right of the employee, of course, this can be invalidated by the court and will be subject to penalty and back wages payment for the employees affected. As of now, the temporary layoff before the pandemic, before October last year, should not exceed 6 months. This is by analogy under the Labor Code, Article 301. If more than 6 months, still under temporary layoff, the employer has the prerogative either to terminate the employee through retrenchment or redundant position, or if he cannot use such authorized causes for such termination, such employee should return back to work, even if not doing anything, and payment of wages should also be returned. Next slide, please. Next slide, please. Yeah. However, as I mentioned, before the October 23, 2020, the period for layoff or forced leave is only 6 months. However, the Department of Labor Secretary Bello issued a Department Order 215 series of 2020, allowing extension for another 6 months, this temporary layoff or forced leave. So, naging 1 year na po ngayon, starting October 23, pag-i-extend po yung temporary layoff. This is unpaid again, provided that this employee shall not lose employment if they find alternative employment during the extended suspension of employment, except of course if the employee decided to resign or voluntarily resign. Hindi siya covered. If he, during the extension of another 6 months, he find a job, before kasi if you're under temporary layoff, if you find a job during the period of your layoff, you are considered automatic resign. But here, hindi daw automatic loss of employment siya. Okay? In case of retrenchment before or after the expiration of the extension, the affected employee shall be entitled, of course, to separation pay, as already discussed under the authorized causes, as the right of the employee to receive as such. However, this Department Order 215 is a very contentious issue right now. There are a lot of labor unions would like to question the validity of this department order on the issue that the executive department of the government cannot revise or amend existing laws. By issuing department order by the Secretary Bello here, he already amended or revised this the 6 months period. He extended to another 6 months, so naging 1 year. So right now, I think there is some workers union trying to question the validity of this department order. However, I'd like to emphasize to you, unless such or department order is not stricken off by the court as invalid, it will be still presumed to be regularly issued. So habang hindi po siya in-invalidato ng korte, tuloy-tuloy po itong Department Order 215. Next slide, please. And finally, of course, no, we try to, ito is a very big issue right now, safe working conditions. This is a requirement by the Department of by the Labor Code under the occupational safety standard, health standard, which every employer must follow. So what is this safe working condition? Safe working conditions is employer must provide workers with every kind of kind of job, protection against injury, sickness, or death through a safe, healthful working conditions. Yan po sinasabi ng basically the concept of safe working conditions. So next slide, please. Based on this and because of the pandemic, the government tried to issue a interim guideline in order for those who will return to work during this existence of pandemic, how to prevent and control COVID-19 so that the working environment will be safe. Under the guidelines by the DTI and the DOLE, the basic principle will be increased physical and mental resilience, reducing transmission of COVID-19, minimize contact rate, and reducing, of course, the infection of COVID-19. Next slide, please. Under in this, we go back again. Sorry, we go back to the first slide, the previous slide. Can we go back? Yeah, this interim guidelines. No, I will just the interim guidelines provided by the DTI DOLE. I would like to emphasize, of course, under the DTI guidelines provided by the DOLE and under the guidelines provided by DTI and DOLE, it is the duty of the employer to provide necessary policy. For the employer, must mandated to create policies in preventing this and preventing the spread and to control the COVID-19 here in the workplace. And he is also mandated by these guidelines to provide resources and materials needed to keep workers healthy in the workplace and safe. And this is very important. Under the guidelines, the employer is mandated to designate a safety officer to monitor COVID-19 in preventing and control measures here. And he is also encouraged to enhance health insurance provisions of the workers. Ito po yung mga health like HMOs coverage, ganyan, or other health insurance coverage that he provides with the employees. And if feasible, he should, if feasible, he provide shuttle services for the affected workers or even accommodations on near-site locations to lessen the transmissions of COVID, especially those commuting workers to help prevent further infection when they go using public transportation. And it is mandated for this employer to put up hotline and call centers for employees to report if symptomatic and daily monitoring scheme. These duties of employers are being monitored by the Department of Labor, whether or not the policy that created in preventing this COVID transmission within the workplace are being followed or not. So they are required to submit to the Department of Labor. There's this policy of safety policy of preventing or the infection, including the social distancing and that should be enforced by the employer properly. Of course, it was included in the guidelines of the duties of the workers. Of course, the workers also have to, or the employees, of course, have to properly observe the policy issued by the employer regarding this. And of course, have to use the social distancing even during the workplace, avoid crowding in one space while working here. Okay, next slide, please. Including in the guidelines of the issued by the DTI and DOLE is that the employer has the duty to give proper protective the PPEs, face masks, personal protection equipment, face mask, face shield, They have to disinfect the facilities, provide hand sanitizer, those things. Those are requirement issued, which is supported by the next slide, please, by the Labor Advisory Number 18/0/2020. Here, under the Labor Advisory, the Department of Labor state that who will shoulder the cost for these prevention and control measures. That says that the employer should shoulder these costs, and then not in any way be deducted to the wages of the employees. Okay, so that's clear. Next slide, please. Pursuant to such act, if pursuant to the interim guidelines provided by the TTI and the Department of Labor, and the right of the workers to have a safe working conditions at the place of his work. Is as the right of a workers to refuse dangerous working conditions. Yes, if there is an existing dangerous working conditions in the workplace, he has the right to refuse. This is pursuant to Republic Act 1105, signed by President Duterte, titled an act strengthening compliance with occupational safety and health standard. A worker may refuse work if the Department of Labor and Employment determine that an imminent danger situation exists in the workplace that may result to death or illness. If the Department of Labor thinks that the workplace of the employee concerned, there is an imminent danger that may result to death or illness, the workers affected may refuse to go to work. Next slide, please. So, of course, what is considered imminent danger? In order for us to apply the right of the workers to refuse work due to imminent danger, we have to define what is considered imminent danger. This is a situation caused by a condition or practice in any place of employment that could reasonably expected to lead. We have to use the word definition, the word reasonably expected to lead to death or physical harm. Okay, reasonableness as defined under different jurisprudence by the Supreme Court. It depends on the circumstances and case-by-case basis. Next slide, please. Under the as requirement of the Act of Strengthening the Occupational Safety Health Standard, the Department of Labor issued a implementing rules and regulations under DO 198-18. Under this implementing rules and regulations of the Republic Act 1105, in order for a requirement that there is an existing imminent danger at the work site, these are the process that the employee and the employer should use. If the workers think that there is an imminent danger in his workplace, he must directly report it to the Department of Labor or other competent government agency. And it also gives authority for the safety officer the discretion to implement work stoppage order or suspensions in cases of imminent danger. And a work stoppage order shall be issued as confirmed that the Department of Labor thinks there is an imminent danger in the workplace. And if these requirements have been complied with, the workers now may validly refuse to work until such time that the work stoppage order is lifted. His refusal, will he be entitled to wages? Yes, he is still entitled to wages until up to the time that the imminent danger subsided already. Okay. So next slide, please. This is a very good question right now. Is pandemic considered an imminent danger? This is again a very contentious issue right now. Is 19 in the workplace. No, an employer may insist that the mere existence of COVID-19 pandemic should not amount to an imminent danger in the workplace. If, again, I'll emphasize this, if that he has provided the necessary precautionary and safety measure to protect its employee upon returning for work, and that he faithfully complied with the occupational safety and health standard and the minimum requirements set for a safe working environment during the pandemic. So ibig sabihin po, if he follows the requirements set by our government, like submitting his safety policies, complying with the safety, social distancing in the workplace, and all of those things that requiring by law, he can insist that the mere existence of COVID-19 should not be considered an imminent danger. So can, next slide please. If there is no, here already, these are the minimum requirements. That there is already a company policy preventing the control of COVID-19, providing necessary resources, materials to keep employees safe in the workplace, and you have to designate safety officer to monitor the prevention control the measures, and establishing COVID-19 helplines. If all of these requirements are now complied with by the employer, can now the employee refuse to go to the work site, even there's a return to work order because of the pandemic? Of course, the answer will be no. You cannot validly refuse that there. If his ground for refusal to go to work is merely because of the existence of pandemic. Of course, it will be a different circumstances if there's already a widespread of infections in the workplace. There is already a considered an imminent danger situation. In such cases, if there is a widespread infection in the workplace, he can validly refuse to go to work, and he will be entitled to, of course, payment of wages while not working, until at such time that the imminent danger in the workplace subside or already wala na, so already disappear. Okay, so next slide, please. Oh, that's it. So hopefully, thank you very much. That's the basic basic rights of the employee now being affected by this pandemic, and hopefully you guys, everyone, have got such information and knowledge and can apply now to your business. Thank you. Thank you very much.
Thank you very much, also, Attorney Mike. See, we are not, hindi kami nagbibiro when we said that the law is so wide. So, in fact, we only have a very limited time. We only have about less than 15 minutes for Q&A. So let's just dive right in, Attorney, because we have very engaged audience this afternoon from nationwide, as far as South Cotabato, Iloilo. So, for our first question, Attorney Mike, in our current situation where most are on work from home or blended, how about those employees na naka-work from home who are inaccessible or unreachable most of the time? Can we use that as grounds for gross misconduct?
Yes, yes, we can use that for gross misconduct or even willful disobedience of the law for order, as already mentioned before, no, if the conduct of the employee is willful and intentional, they're not really wrongful. They don't go to work for no valid reason. So yes, it is considered an authorized just cause for their termination or even or penalized to be disciplined. However, I like to emphasize, if you try to discipline an employee, it should not be automatically termination. Under our jurisprudence or court ruling, no, the penalty to be imposed must be commensurate to the transgression committed by the employee. So hindi po kagad siya automatic termination. It all depends on the facts and circumstances. If 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 you think if the transgression is not enough for termination, pwede naman po suspension or other form of ano. It should always be consummative to the transgression committed by the employee.
All right. Thank you, Attorney Mike. So it really depends on the facts of the case pa rin, diba? So how about kanina you've mentioned about management prerogative. So can management force an employee to report to work even if there's a memorandum of understanding between management and employees regarding the extension of flexible work arrangement? Or like if the employee also will tell us, I don't want to report because I don't feel safe. May internet naman sa house ko. So what can management do?
Well, again, we have to go back to the guidelines, no? As already guidelines issued by the DTI and the DOLE, and even the Republic Act 11058. If the employer has complied with the minimum requirement for the safety conduct of operations within the work site, and he already provided protections or social distancing policy procedures, there is as for my legal opinion, there is no valid ground for the employee to refuse to work already, because as already mentioned, our government is already trying to open up economy right now, opening up business. So I think unless of course if it's existing physical or medical situation, that can be a valid ground for not going to work. But if it's healthy, I think and the employer is complying with the minimum standard required by the law. So I think it will be the employee will be in the losing end here. However, again, it will be depends on the case by case basis. There is no fast hard rule regarding this. This is a very contentious issues right now, whether pandemic is considered imminent danger. And until up to the point that the court or the Supreme Court says that pandemic is considered an imminent danger. So as of now, there is no real definition whether the pandemic is still considered a imminent danger. So it's all open to interpretations, and it can only be answered if there is a case filed against it. So I hope sana meron para malaman natin talaga.
True. Indeed, Attorney Mike, no, diba, law is indeed not an exact science. So kahit mapunta man yan sa Supreme Court, there's always a concurring and dissenting opinion pa rin. So anyway, with regard naman, Attorney, how about for working arrangement for pregnant employees? Can employer make them work on site? So kasi parang, if I remember it right, parang yung IATF, hindi pa siya super clear eh. So if they can work from home, it's okay. But if they cannot work or the work cannot be done at home, does this fall on no work, no pay?
Pregnant, you're talking about pregnant employees.
Yes, yes.
Okay, they are excused to work right now, no? Under the general community quarantine guidelines by the IATF. Those persons who are age 60 more than 60 who have comorbidities or high-risk pregnancy, they are required, they are not actually being mandated to go to work. They are protected. However, of course, if there is a other work, flexible working arrangement or work from home arrangement, of course, her refusal to go to work from home, to agree to work from home arrangement is not valid. In such cases, if it doesn't work, there will be the doctrine of no work, no pay will apply.
Attorney Mike, how about on the flip side na kasi the employee don't want to lose pay, so kahit pregnant siya, she wants to go to work. Can she sign a waiver?
Yes, of course, that will be the choice of the employee. That's already her choice. If you want to go to work, okay, go ahead and go to work. Provided, of course, for the protection of the employer, we have to ask for a document stating that this is your own volition to go to work, even though you are not required to work. And for us to be protected in case there is an incident that transpired because of your presence in the work, well, I advise for the employer to have such a document waiver.
Thank you, Attorney Mike. We have another, as in grabe talaga, sumasabog na yung Q&A natin dito, Attorney Mike. So, madaming phone-in question. The company is providing vitamin C, face mask, hand sanitizer in their work areas and doing pep talk to employees to strictly follow health protocols. What are the employer's obligation to an employee who tested positive for COVID-19 on site?
Well, it all depends on it all depends on the circumstances. If the employer were negligent in enforcing the protocol, the safety protocol that he have submitted to the Department of Labor for in order to comply with the return to work compliance, and so if he's negligent to that in enforcing it, he should be liable for any expenses incurred by the employee, because especially, of course, because of the failure of the employer to prevent the infection, the employee will not, if they properly just enforce the safety protocols of the company, the policy, it will not happen. If they're negligent, well, they have to pay for it. It's a breach of contract. You remember that the employment contract is a contract between the employer and the employee, and one of the obligations of the employer is safe working conditions. So if the employer breached that obligation to have a safe working conditions within the premises, you should be liable for it.
Thank you, Attorney Mike. There's already a request to extend. So, good news, we will extend it for another 15 minutes because ang dami talaga, so that we can accommodate more questions. So, is hazard pay required for employees working during pandemic in a private sector, for example, and manufacturing setup?
Unfortunately, no, it's not. Because if the hazard pay, but the purpose for the hazard pay is because of the pandemic, no. President Duterte issued Administrative Order number 35 and 36. This hazard pay only refers to those frontline health workers, which they'll be required to have a additional 5,000 per month as an hazard pay. However, under Administrative Order number 36, nalagdagdagan po siya ng private companies. Pero yung private companies po only refers to frontline health workers who are taking care of or being exposed to those COVID-19 patients. Other than that, there is no law providing or mandating hazard pay. If it's the discretion, of course, of the management. If they want to pay hazard pay, they can. There's no prohibiting them to do so.
So thank you, Attorney Mike. How about shuttle? So are companies required to shuttle employees
if applicable, it's not. It's really highly encouraged to do so. Of course, it is a management prerogative to how he can. It's up to the management how can he efficiently run his business operations. If there's no funds for that, how can he like be forced to do that? That will be considered an oppression. It's already a part oppressive action on the part of the government if you try to mandate that. However, if the employer can, why not?
True, thank you. If an employee refuses naman to undergo swab test or rapid test, is it one of the best practice to keep them on floating status, or is it an exercise of bad faith?
If the
If
employee
the
refuses
employee
to swab
refuses,
test,
may protocol yung company na i-swab, so ayaw ng employee.
well,
May company policy,
that would be okay.
there's a company policy na the employees are required to undergo swab and rapid test. So ayaw, before reporting. So ayaw ng employee. So number one, can the employee refuse?
If the company policy agreed by the employees as a whole, this is how we do it. A company policy is considered, or rules and regulations are considered part of the contract of employment. Even if during that time he signed the contract, tapos merong bagong policy issued by the company, and this employee have understanding of this policy, it becomes form part of their contract of employment. If they breach this policy or they don't want to follow this policy, is it considered a breach of obligations on the part of the employee? In such case, he can penalize for that disciplinary action for that. If his refusal has no valid grounds, if he say he just doesn't want to have, for some reason, na hindi naman siya valid, that can be considered a willful disobedience on a lawful reasonable order of the employer. Diba?
Kasi we also want to protect.
I don't see in any way a reasonable ground. Yeah, reasonable grounds for an employee to refuse. Yeah.
So,
And besides, no, we have to always to take into consideration this testing when it becomes a policy should be shouldered by the company. If they decide to put it in a policy.
yeah. Yes. Then
Pero
what if
iba usapan ko pag ang swab test, mabayad si employee. Pwede siya mag-refuse. Ayaw ko
Attorney Mike,
magbayad.
on the other side po, sorry, na if a floating status daw, yung employee, if company paid naman siya. So if a floating status pag ayaw ng employee, is it an exercise of bad faith on the part of the company?
Floating status as a part of a penalty for refusal.
Opo.
Well, it depends on their code of discipline. If floating status is part of their penalty for transgressions of the duty of the employee, pwede naman po. Pwede siya. If it's not a part of the code of discipline of the company, I think floating status will suspension. Pwede. Yeah, suspension maybe can be. I don't think it's a floating status but merely a suspension. Although kasi pag sinabi po kasi floating status is this employee still working but no duty, or he was prevented to go to work, and with that no work no pay scenario. If that's the case, that's already considered suspension and not a floating status.
Sige. Doon naman tayo, attorney, performance naman tayo kasi naka-enter na sila. So, in managing the performance, can management say that those on work from home will get no increase while those on-site workers lang yung bibigyan ng merit increase, yung appraisal increase?
Oh, no. Under the Telecommunicating Act of Republic Act 11165, those who are work from home should have the same privilege as those who work from site. So dapat po pare-parehas yan. Because again, we try to emphasize before before agreeing to work from home arrangement, that the employee should agree to it. Should agree to it. And if the work from home is permanent, there should be an agreement. If it's temporary, only a mitigating measures for such to prevent further losses due to the pandemic, that will be a different story. But if you're talking about a permanent work from home arrangement, it should not get affected yung rate niya as compared to those working under the workplace.
How about po, nag-work na sila. Let's go to termination now. So, since most are working from home, do we still need to send, hindi naman termination agad, do we still need to send hard copy of the notice, warning, yon, termination letters, or can we
Okay.
just send it via personal or work email?
Yes, email will do under our electronic evidence rule, as already in consonance with the e-commerce law. Emails, other electronic documents are considered best evidence document also. So pwede po yan, emails, provided again if the complaining party would like to say contend the authenticity of the document, the email document, pwede naman din po, karapatan din naman niya pong ihabla kung tingin niya hindi authentic yung email document. But that is a different story. But as a basic rule, yes, emails or other electronic documents are considered a valid evidence of a document, even in cases in court or in labor cases.
All right. So meaning then, attorney, instead of the registry receipt sa kung via registered mail, the sent items pwede na yon. That can, in lieu of that. If
But to,
the employee doesn't have-
better advice will be make it to email and registered mail. It's better.
Yeah. How about
Nothing to
hearing, attorney? How about hearing via webcam? Legally acceptable ba siya during this pandemic?
Yes, legally acceptable. Even not during pandemic, it's still acceptable. Yes, provided that you recorded it, and while recording it, all participants were aware that such proceedings are being recorded for purposes of documentation. Again, of course, if not consented, you might be violating the another law, the anti-wiretapping law. So before recording any meetings through web or others, you have to get the consent of the parties.
Attorney, how about this? Some of our business premises are currently, complete the facts, yung facts niya, attorney. Some of the business premises are currently closed due to government instruction or policies due to pandemic. They will hire people once they can open the premises. Dolly rule that they can put the employees under temporary retrenchment for a period of 1 year from the start of pandemic or up to March 16, 2021. But as of this moment, their business is still not fully operational. So is their company obliged to pay the retrenchment pay? If the company, and then if the company will be paying, how about the employees who are already employed by other companies, but just concealing it to get the retrenchment pay? How can they know that, or what will be their recourse? So,
Yes,
and if the
as
employees last na lang, marami siya attorney, eto parang buo na siya. If employees choose to be retrenched, but the company did not want to leave the company, do the company have the right not to pay them the retrenchment pay? Ang dami ah.
pag ganito, pag ganito po, no, if there is a suspension, a valid suspension issued by the Department of Labor, so it means already it's already within the power of the labor Department of Labor, and of course the employer cannot do anything about it. It is a valid exercise of just suspending or forced leave this employee. Of course, papasok po yung no pay, no work, no pay doctrine here. You are not mandated to pay here. Again, if after the 1 year suspension is already done, and uh, the employer thinks it is within his prerogative, thinks na loss of business na, he will close it na already or try to retrench to prevent further losses. Pwede naman po, provided that he will have to pay separation pay. For those who are, except if the closing of the business is if the closing of the business not because of business losses or because of business losses, so sorry, of course separation pay is no longer viable. Wala nang pera, di ba? Hindi mo na mapipilit magbayad kung wala nang pera. And for those under a forced leave within a year, as provided under the Department Order 125, I think that one issued by Secretary Balbanero October 23. If they are working already, it should not be considered a resignation of their previous job, of their job with the employer being have to issue the forced leave. If we follow that, and until now, the validity of that order is still not being questioned, so it's just a presumptions of regularity, and you should be followed that.
Thank you, Attorney. Nag-overtime na actually tayo. So last question. Can the company or employer require all employees to be vaccinated as a condition to return to work?
There is no clear rule there, no? Unless, of course, the employee will have to agree for the vaccination. There should be a consent on such part. Because there are, if it's up to, it cannot be forced. There's basic rule, not only in labor, but basic rule in law. You cannot force a person if he doesn't want to do that, except, of course, if you committed crime, di ba? Kulong ka, bayad ka, gumawa ka ng kasalanan, kulong ka. But if there is no transgression under the law, hindi ka pwedeng pilitin gawin ng ayaw mo. If that is the case, will be involuntary servitude. Or at least a transgression of your right to person or property or liberty.
Thank you, Attorney Mike. Amazing audience this afternoon and great conversation. Thank you for your question. As much as we want to cater to all of your questions, we have very limited time, but don't worry. The organizers took note of your questions, and Attorney Mike is gracious enough to agree that he will answer all your questions minus his billing. And those who invited you will send back the answers of Attorney Mike offline via the contact email you provided when you registered. So thank you again, Attorney Mike, for being such a good sport and for your generosity in imparting your legal knowledge to us. At this point, may I call on our Senior Vice President, Sir Norman, to read of Attorney Mike's e-certificate.
Wow, that was amazing, Attorney Mike. Akala ko I was listening to Kuya Kim. You answered the questions. And I see 41 more coming in, but anyway, that would all be answered soon. Thank you, Attorney Mike. We'd like to give you a certificate of appreciation. Let me read it for you. This certificate is proudly presented to Attorney Michael A. Balbanero as a guest speaker for imparting his valuable insights and inspiration during the HR Cafe entitled Labor Concerns During a Pandemic, given this third day of March 2021, signed by yours truly, Gerardo de la Cruz and Ms. Janet Natonton. Thank you, Attorney Mike, for your gracious time. Thank you all participants for staying this afternoon.
Thank you, Sir Norman. Thank you, Attorney Mike. So, in closing, let me share my takeaway. I think 2020 had the most number of department Sorry, nawala. So am I back? All right. I'm using Attorney Mike's video. So, yon, technical difficulties, very normal in our setup right now. So in closing, as I was saying, let me share my takeaway. I think 2020 had the most number of department orders from DOLE. That's why I understand the numerous questions and the confusion. So because no one was prepared for COVID-19 and its effects, this brings me back to the words of our chairman. We don't know what 2021 or even beyond will bring us. Thus, we have to dig deep to our purpose and our humanity to weather this storm. Our purpose, or simply our why, will guide us and keep us going in these uncertain times. Humanity will enable us to be sensitive to the needs of the stakeholders. We need to put our humanity back to every stakeholder's engagement. We need to empathize to the people, our customers, our providers, partners, suppliers, and shareholders. Whether you are an employee or an employer, if you have a job now, be grateful. Now is not the time to be exacting or asking and demanding for this and that. We need to pause, assess, and analyze and act according to common good and achieve win-win, right? So, because only then, when we achieve win-win, we can only say that we triumph this together as a nation if everybody wins. So thank you everyone for the time that you spend with us. Thank you to our for our sales and marketing team for organizing this HR Cafe. So don't forget to follow the FB, Instagram, and Intellicare account so that you can watch out for the next schedule of our HR Cafe and as well as the topics. And if you have suggested topics, feel free to comment or reach out to us. So again, this is Ivy Zaldariaga from Intellicare Group HR saying good afternoon and be safe, everyone.